My topic that I will be illustrating and elaborating upon is gift in Indian law. What is gift? Gift is the voluntary transfer of ownership from one individual to another individual, which does not involve any sort of consideration. It is considered to be out of willingness, gratitude, love, and affection. The sections which govern this very concept of gift are ranging from sections 122 to 129 of the Transfer of Property Act 1882. The concept of gift includes both movable and immovable property. What is the definition of gift? Gift is nothing but transfer of a portion of an existing movable or immovable property from the owner to any person to whom the owner wishes to transfer the property. Here, the person who is transferring the property is the donor, and the person to whom the property is transferred is the donee. Now, the essential elements of gift are as follows: transfer of ownership, existing property. The person who is transferring the property should have a property that is existing and that is in his own name. The entire process should take place in a voluntary manner. There should be free will and consent. Then the transfer is made without any sum of money or transaction or consideration. Finally, it involves acceptance of the property. After the property is transferred in the name of the donee needs to accept the property to make the transfer of the property valid. There are certain essential elements of a gift to be valid. Firstly, there must be a donor, and the donor must be competent. He must be a major. He must have attained a majority. According to the Indian Majority Act, he must be 18 years and above. He must have a sound mind, and he must have full ownership rights and rights to transfer the property. Secondly, there must be a donee. The donee must accept the gift during the lifetime of the donor, when the donor is alive, during that period of time. The consent must be voluntary. It must be free from coercion, any force, any pressure, any undue influence, or fraud. Then there must be a property that is existing. Any future property cannot be gifted. Only property which is existing, that can be and may be gifted. Finally, there must be an instrument that is registered. Only through a registered instrument can the property that is immovable in nature be transferred from the donor to the donee. There are different types of gifts. Firstly, gift between living persons, living beings, that is referred to as the inter vivos gift. Secondly, gift that involves a certain proportion of burden or obligation to repay under section 127, that is onerous gift. Next, there is universal donee, the donee who receives all properties under section 128 of the concerned act. Finally, gift mortis causa, that is a gift made in contemplation of death. This type of gift is not valid under the concerned act, that is the Transfer of Property Act. There are certain formalities before any transfer of gift of an immovable property can be made. Firstly, the gift must be made in writing. Secondly, the gift must be signed by the donor. Thirdly, gift must be attested by the two witnesses. And fourthly, the gift must be registered under the Registration Act of 1908. Now, what is the meaning of revocation of gift under Section 126 of the TPA Act? There are certain grounds for revocation mentioned underneath. Firstly, revocation of gift can be made via mutual agreement. Secondly, it can be made on a specified event, not depending on the donor's will. Thirdly, and finally, there should be no incorporation of fraud, coercion, or misrepresentation in this case. A very renowned case law has been mentioned in this slide by me. That is K. Balakrishnan versus K. Kamalam, 2004 case it is, stating that gift is considered to be irrevocable in nature if it is unconditional in nature. Certain renowned case laws and landmark judgments in the regard of gift. Firstly, Reni Kunsla Rajamma versus K. Sarvanamma. It is a 2014 judgment stating that oral gift of movable property is valid even if a gift is made not in writing and orally. It is considered to be very much valid and significant in law. Secondly, there is the case of Narmada Ben versus Pranjivandas. It is a 1997 judgment stating that undue influence will invalidate a gift. If a gift is encroached upon with undue influence, pressure, force, in that case, it will render the gift invalid. Finally, there is a case of Thakur Raghunath Ji Maharaj versus Ramesh Chandra. It's a 2001 judgment stating that acceptance of a gift must be made during donor's lifetime. That is again a part and parcel of the essential ingredients of making a gift valid under the TPA Act. Now, what are conditional gifts? Gifts that can be subjected to a condition. That might be a precedent condition that has already happened before making the gift, or a subsequent condition that upon the fulfillment, upon the happening of an event, the gift would be made. Secondly, if condition is of such a nature that is illegal, immoral, or opposed to public policy, in that case, such gift will be considered to be void. Exceptions under gifts in Indian law. Firstly, we will talk about religious or charitable gifts that are not governed by the TPA Act. This type of gifts are only made for religious or charitable purposes. Religious purposes may incorporate and include temples, any religious institution, and charitable purposes may be gifts made in charity for helping the poverty-stricken group of the society, mainly. Secondly, we will talk about the Muslim law, hiba, that is stated as gift under Muslim law, which states that an oral gift is considered to be valid only if it is accepted and the possession of the gift is given. In summary, we can summarize it as follows: that firstly, gift must be voluntary, unconditional, and accepted. Secondly, registration is completely required for any transfer of ownership of immovable property. And finally, revocation, that basically means the cancellation or annulment of a gift deed, is only allowed in limited cases. I have added certain FAQs in the slide. Question number 1 stating that can a minor give a gift? That is absolutely not possible. Secondly, is consideration allowed in a gift? Absolutely no. Finally, are oral gifts valid? Completely yes. In cases for only movable property recognized by the TPA Act. Certain references that helped me to complete my presentation are as follows. Firstly, I have used the Transfer of Property Act of 1882 to make certain uh, concepts in this PPT. Secondly, Supreme Court judgments that I have cited, I have taken it from certain well-renowned sites, like for example, the Indian Qanun and various other platforms like Case Mine, etc. Thirdly, I have referred to the book written by Mullah on Transfer of Property Act. Concluding, I have even referred to SCC Online and Manupatra for referring to certain judgments. Thank you. This presentation was made by Samriddha Ray, a third-year student studying BA LL.B. Honours in St. Xavier's University, Kolkata.